Hi, I'm Elizabeth Gearhart. I'm here with Richard Gearhart, founder of Gearhart Law, an intellectual property firm that does patents, trademarks, and copyrights both domestically and internationally. And we're going to talk about a frequently asked question. So people often call and say, what is a PCT application?
It is one of the more frequent questions we get, and PCT stands for Patent Cooperation Treaty. And it's a way to file your patents internationally. So if you file a patent first in the US and you want to protect your idea in different countries, Europe, Japan, Canada, Mexico, you can do that. And the PCT application is one way that people are able to protect their intellectual property internationally.
So it's actually a treaty, right, between the United States and all these other countries.
Right, exactly. And virtually every country is a member of the PCT treaty. There's a few that aren't in Latin America. I think Argentina is not. But for the most part, filing an application under the PCT allows you to delay filing individual applications in each country where you want patent protection.
So if I come to you and I want to get a patent on an invention, and we do the United States, say we start with a provisional application because that's normally what we would do, right? Mm-hmm. And then a year later we file the utility application. When do I have to decide whether or not to file a PCT application? How much does that cost? How much does that add to the cost?
So usually you'd want to file a PCT application within 1 year of your first filing.
So when you file the utility, if you've done a provisional.
Right, you would file it at the same time as you file the utility application, typically. That gives you an additional 18 months to make a decision about whether or not you're going to file the application in countries outside the US. So the PCT is a way to defer your foreign filing decisions for an additional 18 months. Past when you would otherwise have to make that decision.
So how much does that cost typically?
It's usually, it depends on a lot of factors. It depends on the page length. It depends on the search authority, that is, which country actually does the patent search that comes with the PCT. But in general, it's around $2,500 for the WIPO fee, or the International Search Authority fee. And then, Gearhart Law also charges a fee on top of that to process the paperwork and monitor the application.
So let's say I had a 25-page application with 20 claims, and I wanted to file a PCT. About how much would that one cost?
It would be probably about $2,200 to $2,500.
And then what would the Gearhart Law fees be?
It would be about $800.
So a little over $3,000. And then I have a year and a half. So I guess the purpose of this is to say, okay, let me see if I can commercialize this in the US. And if it looks like it's catching on in the US and I'm getting sales, then maybe there's some other countries I want to file in it.
That's part of the reason for filing the PCT. In the patent world, the name of the game is deferring fees and costs as long as you can, because you do want to see if there's a market for your product in Europe or China or Canada before you pay the patent fees to prosecute the application there. Another piece of it too is if you're looking for investor funding and the product has global appeal and you're trying to appeal to investors, lots of times having the opportunity to file globally with your technology makes your project more appealing.
So basically what you do is you take the patent application that I filed in the United States and you send it to like the Korean authority or somebody, right? For PCT or?
Yeah, there's a receiving offices and then there's search authorities, and we'll help figure out which receiving office it would go to. Normally we would file it with the US as the receiving office. And then they're the ones that receive the application and process it. Then there's also a search that goes with the PCT application. You can choose Europe or the US or Korea or Australia to actually do the search. And then you get a search report back, an international search report that all the other patent offices typically review and take into consideration as your application would go through their countries.
So if I've done a patent search before I started my US application, how is that international search different, or is it very different?
They may be slightly different in the results, and so you would have then two searches.
Okay, so then I've done that, and now it's 18 months, and I decide, well, I would really love to file in 100 different countries, but I think it's kind of expensive. So let me just pick one other country right now to file in and get the cost on that, and then see how many countries I can actually do. So let's pick the EU because that's like a big thing. So how much would it cost then? So then it's, what is it called? Nationalization?
No, if you want to receive patent protection in Europe, we would file the application with the European Patent Office. The cost of that is usually between $6,000 and $7,000. It goes through an examination at the European Patent Office, and at the end, you decide then which countries in Europe you want the patent granted in. So you would go through the European Patent Office, and then at the end, if you're successful, you might want the application in the UK, in France, in Germany, Spain, any one of the many EU countries, and it can be, and that's what the nationalization process is.
So when you pick the final country where you want it to be, like, then that's called nationalization.
Right, right.
So that means that it's a patent in that nation, kind of.
Right. So if at the end of the 18-month period, you decide which countries you would want to enter from the PCT. And so you may select China, the EU, Canada, Brazil, and then we would file individual patents in each one of those countries through patent agents and attorneys that are located in those countries.
And it's about 10,000 a country, you think, or?
Right. We estimate 10 to 15,000 per country from start to finish per application. So it would cost probably, in some countries like Canada, it's relatively inexpensive. In other countries like Brazil, it's more expensive because the application has to be translated into Portuguese. And so the costs become, for the application, start to rise the more countries you select. And in addition, unlike the US, most other countries have taxes or maintenance fees that need to be paid on a yearly basis, which add another $500 to $700 per year onto the cost of the application per country. So if you want to do a large international filing, you want to select maybe 10 countries, then the cost overall over time would probably end up to be around $150,000 to globally protect the technology from one application.
So I guess it's really pretty much the big companies that do that. So then another question I have, so let's say that I'm going through this process here and maybe in England. And my application gets granted here but gets rejected in England. Will that affect my application here at all, what happened in England?
No, I mean, that's a great question, but normally the patent offices don't pay attention to the prosecution of the application in different countries. So it's really just what happens in that individual country.
So then if I'm British and I'm living in England and I file my application in England and I want to do a PCT and I want to file in the United States, then that's called a U.S. nationalization for me?
Right.
Okay. And how many countries, like, it's over 150, right?
Yeah.
They're part of this treaty?
Right. I think it's over 180.
So the whole purpose of the treaty really is to give people that time window to decide how much money they have to spend on it. That's part of the process.
Right. I mean, and that's that helps everybody by, deferring costs. Right. And making that big investment only when it makes sense from a business perspective.
So how many of your clients do you think actually do the PCT placeholder?
I would say 50% of our clients do the PCT placeholder, and then of those, probably about half actually end up filing patents in foreign countries.
So what happens if I don't file the PCT application within a year of my first filing of any type of other application, provisional, utility, what have you, I don't file it in time, and then I decide like a couple years later, hey, I really do want to do this in England or somewhere. What happens?
Well, unfortunately, you're in a little bit of a bind, and so you probably wouldn't be able to file internationally if you don't file the PCT application within that 1 year period. There are some exceptions to that. It's possible, depending on the circumstances, to file the PCT application as late as 6 months after the priority date or the conversion date is missed. It's really best to file the PCT application within 1 year of the originally filed application. And most countries are not so forgiving if you miss the nationalization deadline of the PCT. So, for example, the PCT allows you to defer filing in foreign countries for a period of 18 months. But if you miss that 18-month deadline and you don't file in Japan or Australia or Canada, then most countries don't give you a grace period. There's a few, like the European Union, that give you an extra month. Canada gives you extra time too. But countries like China, Japan, and most other countries don't allow you to file international applications off of PCT past the 18-month extension. So you really have to make up your mind, within that time frame and make a decision. So unfortunately, the rights can be lost if you don't file the applications in time.
Let's say I feel like I want to file in the US and I want to file in England, and those are the only two countries I'm ever going to want. So I file my utility application in both of the US and England, and I get the date, the filing date, which is important, as we've discussed before. Should I still do a PCT just in case? Or do you think, what would you advise a client in that situation?
It depends on your budget. If you have the money to file a PCT application anyway, and the $2,000 or $3,000 investment is a small part of your overall budget, then it may make sense to do that just to keep your options open. If, on the other hand, you're a startup and that $2,000 or $3,000 could be better spent on marketing or some other expense, then if you're pretty confident that you're not going to sell the product anywhere except the US and in England, it may make more sense just to spend it on other business expenses.
Okay. Is there anything else about PCT? Patent cooperation treaties.
I would only say that it's a great option. It's a great way to manage your intellectual property budget. And relative to all of the other expenses of starting a business, the $2,000 or $3,000 that you might spend for a PCT application is a good investment if you think there's any chance that your product might be sold overseas someday.
And investors like to see it.
And investors like to see it too.
Okay. Well, thank you, Richard.
Well, thank you.
And if you need any help with foreign or domestic patent applications, foreign or domestic trademarks, copyrights, this is the guy to call.
Absolutely. We're available at Gearhart Law. That's GearhartLaw.com. Or you can call me. My number is 908-273-0700.